audience this evening. Welcome to everyone. I'm Linda Lee. I'm a judge on Code of Appeals Division 2. Sorry, it's been a long day. And I want to welcome all of you on behalf of the panel here. I know all of you have had a pretty long day at work, and some of you probably had some troubles getting here, so welcome and thank you. We hope that today's program will be informative and helpful to all of you. What I'd like to do is just give you a brief overview of what we're going to be doing tonight. First of all, we have several speakers this evening that will hopefully provide you with a wealth of information. Speaking first will be Roger Wynne, who's down at the end of the table. Mr. Wynne is with the Seattle City Attorney's Office. He has a degree in history from Yale Law, a master's degree in environmental policy, and a law degree from the University of Michigan. And he's also an adjunct professor at the Seattle University School of Law, and he has a class tonight, so he's going to be speaking first and running away from us. So we will ask that all questions be asked at the end, but with regard to Mr. Wynne, if you have any questions of him about his particular subject area that he's speaking on, please feel free to ask him questions during his talk, because he's going to be running away from us.
Don't take it personally.
I think we did this last time, Judge.
Speaking second will be Mr. Doug Ende. Mr. Ende is, for some of us who are practicing lawyers, a scary person because he is the Chief Disciplinary Counsel and the Director of the Office of Disciplinary Counsel with the WSBA. He got his undergraduate from Johns Hopkins University and his law degree from the University of Washington School of Law. He's a prolific speaker at various seminars, sharing his knowledge on ethics, but I Googled him, and what I found most interesting, which has nothing to do with ethics, but I like to find little tidbits of interesting things about people, and he, in 2003, had his poems featured on the King County Metro Transit buses. So that's ask him about it. It's really interesting. And after Mr. Ende speaks, Judge John Erlick will be speaking. Judge Erlick is on the King County Superior Court bench. He was first elected to that position in 2000, so he's been through a campaign, he's been through the trenches. And he currently serves on the Commission on Judicial Conduct, and he's the former chair of the Superior Court Judges Association Ethics Committee, and a former Ethics Advisory Committee member. So he is Mr. Ethics as well. Judge Erlick got his undergraduate degree from Harvard College and his law degree from Georgetown University. And speaking, our last speaker this evening, and certainly not the least, because she's the most recent who's been through the trenches, so she is a wealth of information, is Judge Vicki Hogan from the Pierce County Superior Court bench. She was first elected in 1992, and her most recent election was in 2012. Judge Hogan got her undergraduate degree from the State University of New York, her law degree from California Western School of Law. She is a former member of the Superior Court Judges Association Ethics Committee and a current member of the Ethics Advisory Committee. So that will be our panel of speakers. You have hopefully all grabbed when you walked in our handout for this evening, the booklet, and it's fairly well organized. Behind tab 1, you will find the actual Code of Judicial Conduct. That's all the provisions. There is a caveat I'd like to point out to you on page 14 of the booklet. It talks about application and Roman numeral 1, applicability of this code. You have A, B, C, and D. In 2015, C was eliminated by our Supreme Court, so C no longer exists, and D is now C. The reason for that was, I believe, the Supreme Court thought that C was redundant, and so because all the roles of what applies to a judicial candidate versus a judge is all spelled out in Canon 4 very specifically, so they thought it wasn't necessary, so it got taken out. Behind tab 2, you will find the rules of professional conduct. If you are an attorney who is running for a judicial position, you need to be cognizant that you're still subject to the rules of professional conduct, and some of those rules might still apply to you as you run as a judicial officer. Under tab 3 are the FAQs, frequently asked questions, and I've gone through many of them. I do want to have a little correction on page 69. Under Roman numeral 1B, and it talks about who must comply with Canon 4. It does reference the application Code of Judicial Conduct, Section 1B. That's a typo. It should just be Canon 4, because it spells out again in Canon 4 what applies to whom specifically. Behind tab 4, you will find our compilation of all of the campaign ethics opinions that have been issued by this committee. And behind, some of these opinions are on the older side. A brand new Code of Judicial Conduct was adopted in January of 2011. And so some of these opinions are based on the old code. And you will notice at the bottom of each opinion, there is a box, and it refers you to the new code section that could apply currently. So even though the decision was based on the old code, please keep in mind the new code applies, and you can see the reference to which code provisions apply currently at the bottom of each box on each opinion. On tab 5, you will find the Public Disclosure Commission materials. It's a very handy space. Remember, as running for office, the Public Disclosure Commission takes control of your life as well, and there are many things that we need to be aware of. And it's a handy space for you right here under tab 5 to look at the different provisions that may apply to you. Under tab 6, we have the Secretary of State's candidate filing guidelines for 2016. Again, it's a handy space all together in one spot for you to refer to in the future if you need to, and I think it'll be discussed this evening as well. There are several sections that are highlighted in yellow within tab 6, and those are sections that talk specifically about judicial candidates, so, and we highlighted those for you. So that's the handbook. We're also going to have, we also found in the materials a separate handout. It's a staple. It's called Scope of the Washington State Judicial Conduct Selected. These are materials I believe Mr. Wynne will be addressing during his speech, so it's a handy separate section. You also have in your materials a CLE form. So if you want to get CLE credits while learning how to run for a judicial campaign, this is there for you to fill out, and there are approved credits for this evening's program. And finally, the last piece of material I'd like to cover with you is the course evaluation form. Because you're getting CLE credits, we need evaluation forms as well. And finally, there are 3x5 cards on your table. We provide those to you, so if you have a question during any of the speakers' presentations this evening, feel free to jot them down, and we'll answer your questions at the end of the evening. So those are, and if you need more, just let us know. Shannon in the back has them. Let me introduce to you the staff of AOC who helps run this committee. Shannon Hinchcliffe and Carolyn Connies. They are most helpful. If you have any questions, call Shannon, and at any time, she is the most helpful person in the entire universe to me as far as ethics is concerned. So with that, I know we have a very varied audience this evening. Some of you are here because you've already announced your candidacy, and you're here to gather as much information as you can about what you can and cannot do ethically. Some of you are maybe just thinking about running and doing your due diligence and coming this evening. Some of you have already run a campaign and perhaps are here to maybe dust off some of those cobwebs from the last campaign election. Regardless of the reason for your being here, I hope you find this evening helpful. And I'm going to stop talking and turn it over to Mr. Wynne.
Thank you, Judge Lee. Now, not only do I have to leave early, so I apologize for that, I also apologize that unlike Mr. Ende, I will be doing my presentation in prose, not verse. But thank you very much, really. I want to convey this heartfelt thank you to all of you. Our system works best when good people step up and say, I will serve. And my gratitude is enhanced because for most of you, we don't let you serve until first you've gone through a political campaign. And to boot, we make you tie one hand behind your back to do it because you have to comply with the rules we're going to be talking about this evening. There are two bits of good news, though. One is that you're not alone. Everybody else has to do it. Secondly, it's for a good reason. Because of the crucial role that the judiciary plays We have a value in making certain that despite running for election, judges both appear to be and in fact are free from political influence and from pressure. And that is what we try to get at in the Code of Judicial Conduct when it comes to elections. So what I want to do with you is walk through the text of the code and try to give you a sense of how that balance is struck between both maintaining the public confidence on the one hand and on the other, allowing you to actually campaign. So as Judge Lee mentioned, I put into the packet this insert. It's stapled. And this is my attempt to condense the parts of the CJC that are relevant to judicial campaigns. I've stripped out bits that are unrelated to that, and I've tried to move the comments in closer to the relevant rules in there. So let's work through this handout a bit. Talk about the structure first. It's like legislation in many ways. It's got 4 components. One are the rules themselves. That's the real stuff. That's the stuff that you will be held accountable to comply with. That's the enforceable part. 2 are the canons. The canons are broad statements of intent or principle. 3, you will see comments. Comments help us interpret the rules, and they also lay out some aspirational goals. But again, the rules are the key. And 4th, like any good piece of legislation, there are definitions, and you find those at the end of the document. But recall that, as with any law, just because you see a word and you think you know what it means, it might mean something different because it's defined. And there's a little trick they use here in the code. In each rule, every time a defined term shows up for the first time, they put an asterisk next to it to kind of remind you, oh yeah, don't think you know what this means, go look it up. So look it up if you see the asterisk. In the scope section here, note also number 5. Reminds us that what we have here are rules of reason that are to be applied as such. They don't trump statutes, they don't trump the Constitution. And again, though, keep in mind, as this reminds us, that the goal here is to maintain the confidence of the public. That really is the reasonableness we want you to keep in mind. If you are in doubt, err on the side of maintaining the public's confidence. So that's the scope section. Let's go in a little bit deeper and look at what Canon 4 says about judicial campaigns. And then my colleagues here will then explore some of the key aspects of Canon 4. Canon 4 can be reduced to 3 words key to any political campaign. Money, what you need to fuel the campaign. 2, speech, what you say in your campaign. And 3, proxies, what other people can do for you in your campaign. So let's look at each of those 3 in turn. First, let's talk about money, and for that we're going to look at Rule 4.1, subsection A, and subsections 7 and 8. So what you see there is that we say don't personally ask for or accept money. And it's the asking for part that can get a little bit tricky, particularly when you are hosting campaign events where asks happen. Now, again, the motivation here is to avoid the perception of coercion or the abuse of your office. And Judge Erlick is going to be discussing that in more detail and more at a practical level, how you can try to thread that needle a bit. The other thing you see here is pretty much a no-duh rule. That is, don't use campaigns for a private benefit. Duh. Actually, the duh is not there. I added that. But still, it's also governed by a statute. So it'd be a good idea not to just pocket it yourself and go to Vegas. Okay, that's money. Let's talk about speech. And another thing, these are not particularly well organized, especially in their form. We did not draft these. Don't blame us. So as I now start to work through some of these, I'm going to have you jump around these various rules. So let's go to 4.2b, 1 and 2, and we're going to talk about speech. You see there, it's okay to speak on behalf of your own candidacy, and it's okay to seek, accept, and use endorsements from anyone you want. But then come the limitations. Now we jump backwards, 4.1a, sub 10. Don't knowingly lie or mislead. I hope that's something you learned from your mother, but just in case, it's here as well. Now, 4.1a11, the next one says, avoid speaking about a matter pending or impending in court. That's one, I'm glad to see the asterisk, impending. That's not a word we use, impending. They could have just said imminent or expected, because that's what the definition says. But if something is pending or impending in court, at least in a way that might affect the outcome or fairness of it, don't talk about it in your campaign. Of course, when you are in court, either as a lawyer or a judge, do your job. Talk all you want about it. But this is for when you're outside and you are campaigning, just best to avoid talk about what's going on in the courtroom. 4.1812, make no pledge, promise, or commitment about matters likely to come before the court if it would be inconsistent with the impartial performance of the adjudicative duties of judicial office. So comments 13 and 14 talk about that a little bit, and they identify some safer ground. It's okay to talk about your personal views on legal, political, or other issues. But it also would be best to tag on at the end of any discussion you have about that in your campaign, what they recommend here. Acknowledge the overarching judicial obligation to apply and uphold the law without regard to your personal views. So again, you can talk about your personal views, but it would be a good idea to remind folks that when you put the robe on and you get behind the bench, you're going to have to follow what you believe at that point to be the best view of the law. Okay. 4.2, now we're going forward again, 4.2A3, you have to review and approve the content of all campaign statements and materials that go out for your campaign. Basically, you have to be on the hook for what people are saying on your behalf. And then 4.2A1, it's the general rule. Act consistent with the independence, integrity, and impartiality of the judiciary. Again, those are all defined terms, and they're all going to be applied using the rule of reason. Now, friends, you've all been to law school, and I've just talked about money, and I've just talked about speech. So I know all those synapses are firing there saying, First Amendment, First Amendment. So let's indulge for just a moment. I don't want you to get too distracted, but let's scratch that constitutional law itch and talk about that for just a minute. So, Republican Party of Minnesota versus White came before the U.S. Supreme Court in 2002. It challenged what used to be a standard provision of the Model Code called the Announce Clause. And it said a candidate shall not announce his or her views on disputed legal or political issues. You should not, let me say it again, do not announce your views on disputed legal or political issues. And the Supreme Court knocked that down 5-4. And the late Justice Scalia wrote the majority opinion saying that rule does nothing, as he can often say, it does nothing to advance the avowed state interest in preserving public confidence in an impartial judiciary. Let me quote him here. A judge's lack of predisposition regarding the relevant legal issues in a case has never been thought a necessary component of equal justice, and for good reason. For one thing, it's virtually impossible to find a judge who does not have preconceptions about the law. And even if you could find such a judge, it would hardly be desirable to do so. Rest in peace, Justice Scalia. The majority said maybe opponents of judicial elections have a point, that it's hard to do elections for judges and respect the First Amendment. But, again, quoting Justice Scalia, but the First Amendment does not permit the opposition to judicial elections to achieve its goal by leaving the principle of elections in place while preventing candidates from discussing what the elections are all about. So you might think, hey, it's a free-for-all. You can say whatever you want. Forget about this, the CJC. I've got the First Amendment, right? Not so fast. So even after we got Citizens United, we then last year got Williams-Yulee versus Florida Bar. It involved a ban on the personal solicitation of funds. And here, by 5-4, the court upheld that limitation. And it was an opinion authored by Justice Roberts. He said, or they, the majority said, it advances the state's interests, both in protecting the integrity of the judiciary and maintaining confidence in an impartial judiciary. Again, I'll quote, judges are not politicians, even when they come to the bench by way of a ballot. And a state's decision to elect its judiciary does not compel it to treat judicial candidates like campaigners for public office. A state may assure its people that judges will apply the law without fear or favor and without having personally asked anyone for money. The state's decision to elect judges does not compel it to compromise public confidence in their integrity. So, sometimes the code wins, sometimes the code loses. 5-4. We could geek out on this stuff all night, but let's not get distracted by this. Sure, if you want to push a free speech claim in opposition to any of the rules we're talking about, you have a right literally to make a federal case out of it. But our pitch to you is to keep the public's confidence in mind. Running for and becoming a judge means making sacrifices, and it means making sacrifices in how you would run a campaign. And again, you have my gratitude for doing that. But those sacrifices serve us well. It keeps the confidence of the public in a very crucial part of our society, namely the judiciary. So, to get off my constitutional law soapbox, let's go on to the third part that we see in the rules here, and that's proxies. Who can help you out? Well, family members, they can. They can ask for and even accept money on behalf of the campaign. And of course, you can set up campaign committees. They can also ask for and accept money, and that's addressed in Rule 4.4, and my colleagues here are going to be digging into that in much greater detail and at a much more practical level. Beyond those exceptions, keep in mind the prohibitions. Specifically, do not, this is another no-duh one, do not use court staff or facilities or resources to run your campaign. Duh. That's 4.1A9. Again, I added the duh. And take reasonable measures to ensure that no one does something on your behalf that the rules prevent you from doing. Again, fairly straightforward rules. So even though they are independent from you, the rules act on this understanding that it is going to be the public's perception that they are acting on your behalf. So they should be following the same rules that you do. So that's it. It is speech, it is money, and it is proxies. That's what these rules are all about. So with that, I want to thank you again for your attention, but more importantly for your willingness to serve our society. It's very important. Thank you.
Great. Any questions of Mr. Wynne? Anyone want to geek out with him?
Sure. I just got a really quick question about judicial staff assisting in a campaign. Obviously, you don't want them on your campaign committee. What happens when your judicial staff wants to put out one of your yard signs?
Well, first of all, I don't know, so I'm going to start making it up. Does one of you know?
I believe that you cannot request your judicial staff to assist you.
Understood.
Your judicial staff may volunteer on their own time.
The First Amendment still applies to them, I gather.
The bright line is are they doing it to keep their job if they're your staff? Are they doing it because they want to? Are they doing it not because you asked? Those are the gray areas.
That yard sign just showed up on my desk. Guess I better put it up.
Oh, dear.
Don't bring yards.
Don't bring it to work.
Don't bring yard signs to work.
Oh, my God.
Okay, there's the practical advice.
Anything else? All right, well, thank you.
Again, I apologize, I have to take my...
And again, if you do have a question that comes up later that Mr. Wynne covered, write it down on the 3x5 card and we'll get the question to him and we'll get it answered. You can't run away.
Or you can answer it, but...
Or we have your cell phone.
Exactly.
We know where you are. If there are no other questions, Mr. Ende, take it away.
Thank you. Again, I'm Doug Ende. I'm the Chief Disciplinary Counsel at the Washington State Bar Association. And as such, my stock in trade is the regulation of lawyer conduct under the rules of professional conduct. I'm here to talk today about attorney compliance with the requirements under the rules of professional conduct and the Code of Judicial Conduct. I like to think of my presentation as really being about the Washington State Bar Association's role or potential role in regulating lawyer compliance as candidates for judicial office. That's a mouthful of words. And the irony is, every year when the Ethics Advisory Committee invites me to serve on this panel, I'm tickled because I really have very little to say. My piece of the puzzle, the Washington State Bar Association's piece of the pie in this work is very, very slender. And I think the reasons for that will become apparent to you as I talk about how lawyers are regulated when they're serving as judicial candidates. But just to prove my point, my materials are at tab 2 of your booklets, and if you look at tab 2, it's a very, very slender tab in the booklet that's been provided to you. I'm going to start by talking about the definition of judicial candidate, and that comes from the terminology section of the Code of Judicial Conduct, and if you want to follow along, you don't have to follow along, but if you wanted to, that definition is on page 19. The definition of judicial candidate is any person, including a sitting judge, who is seeking selection for or retention in judicial office by election or appointment. So obviously sitting judges who are seeking retention are judicial candidates. And other persons, including lawyers, I think the non-lawyer judicial candidate is such a rare bird that we're not going to bother with that today. But a lawyer seeking selection for judicial office by election becomes a judicial candidate. And I know we have some judges here today, and I know we have some lawyers here today. Once you cross the line and become a judicial candidate, and the definition in the terminology section tells you when you make that conversion from sitting judge or lawyer to judicial candidate. Once you become a judicial candidate, you're subject to the Code of Judicial Conduct as applied to judicial candidates, and that's Canon 4. And that's what Roger Wynne just spent 20 minutes telling you about. So really, all I have to say to you, if I was just covering the substantive law applicable to judicial candidates and lawyers who are judicial candidates, is what he said applies to you as a lawyer judicial candidate, because you're all under the same umbrella of judicial candidate once you've made that announcement or you've done the filing or whatever method you use to become the judicial candidate. Now, the reason that's not enough for me to say here today, just look at Canon 4 and remember what Roger said, because there's some interesting procedural quirks when it comes to the authority of the agencies that are responsible for regulating judges and regulating lawyers. So really the remainder of my remarks will be about these interesting procedural niceties, which hopefully you won't need to worry about that much because you'll comply with Canon 4. No one will file a grievance against you, and you won't file a grievance against anyone. And I know that's a perfect world. So the first thing I want you to take note of is Rule 8.2, and that is in tab 2. It's one of the 2 rules of professional conduct that I've excerpted today. And Rule 8.2 talks, and this is the lawyer rules of professional conduct, talks about judicial and legal officials. And 8.2b states that a lawyer who is a candidate for judicial office shall comply with the applicable provisions of the Code of Judicial Conduct. That's what I just told you, but it is set forth in the rules of professional conduct, and it has to be because although you're subject substantively as a lawyer to the Code of Judicial Conduct, the enforcement mechanism for lawyer compliance are the rules of professional conduct. And the Supreme Court, the Washington State Bar, does not investigate, does not discipline lawyers directly under the Code of Judicial Conduct. It's only under the rules of professional conduct. So this is essentially an incorporation by reference and a very simple concept. And that's nearly all I need to say about the substantive law of judicial elections as applied to lawyers. The remainder of my remarks, I think it will be helpful to think about all of the potential outcomes in a judicial election. You can either be a judge as a judicial candidate, sitting judge, or a lawyer as a judicial candidate. If you are a judge and you're seeking retention and you are elected, you remain a judge that whole time. And if you remain a judge the whole time, jurisdiction and authority over judges resides with the Commission of Judicial Conduct. So quadrant 1, judges seek election and are retained, that's with the Commission. Quadrant 2, a judge seeks retention and does not prevail in the election. So the judge becomes a former judge. Under the Commission's rules of procedure, former judges are under the jurisdiction of the Commission on Judicial Conduct. So if there is an investigation, if there's some allegations of misconduct against a former judge relating to conduct in an election, that's going to be looked at by the Commission on Judicial Conduct. That's quadrants 1 and 2. Quadrant 3, you're a lawyer, and you're seeking election to judicial office. And you become elected to judicial office. So you go from lawyer to judge. You are now a judge. If a grievance is filed, it's going to be under the jurisdiction of the Commission on Judicial Conduct. So that's quadrants 1 and 2 and 3. If there's anything to be looked at in terms of ethics under Canon 4, it's going to be looked at by the Commission on Judicial Conduct. And just to reinforce that, if you want to follow along, the only other rule I've excerpted from the Rules of Professional Conduct is Rule 8.5, which defines the disciplinary authority of the Washington State Bar, and specifically paragraph C. And it's a bit of a complicated provision, but essentially what it says is lawyers, while serving as judges or justices, are not subject to the disciplinary authority set forth in the Rules of Professional Conduct. In other words, the Bar Association, the disciplinary authority. That's expressly reserved for the Commission on Judicial Conduct. Now, if judicial discipline is imposed, the Bar Association can look at that conduct as long as it's not conduct that was purely pertaining to the role of the judiciary. If it implicates fitness to practice, for example, post-discipline by the Commission and or the Supreme Court, the Bar Association could look also at lawyer discipline. But if it's purely judicial function, and most campaign conduct is, the Bar Association is never going to take jurisdiction over a case like that. So that leaves me and leads me to my fourth quadrant. You are a lawyer. You are a judicial candidate for office. And as a lawyer, judicial candidate, you do not prevail in the election. So you started as a lawyer and you ended as a lawyer, and never during that process did you become a judge. That quadrant is reserved for the Washington State Bar Association because the Commission on Judicial Conduct does not have jurisdiction over lawyers. So if a grievance were to be filed in that scenario, if a lawyer as a judicial candidate were alleged to have violated Canon 4 of the Code of Judicial Conduct, that would be looked at, that would be reviewed and perhaps investigated by the Washington State Bar Association, but looking through the lens of the Code of Judicial Conduct. We're reserving questions for the end of, but I can take a quick question.
Let me complicate it a little bit. Part-time judge, also practicing law, files for a full-time judicial position. How does that play out?
That's a great question.
Yeah.
I haven't seen that come up. But the Commission would have jurisdiction over a part-time judge, and my sense is under RPC 8.5 that I pointed out earlier, that would come within the reservation of authority of the Commission maybe that'll happen someday, and in 2 years from now, I can have a better answer.
Maybe it won't.
Maybe, I hope it won't. And it is my hope that none of you will receive or need to file a grievance during a judicial campaign. With that, I'll turn it over to Judge Erlick.
But I think we have seen both authorities accept jurisdiction in your scenario. And the bar is investigated because the conduct was bar-related. And the commission simultaneously did an investigation, and both were sort of on parallel tracks. We have seen that.
If it's campaign-related conduct, the bar would probably defer to the commission.
But I don't think it's precluded from dual tracking, so you could get in trouble on both sides.
I think that's a question I had. You talked about your 4 quadrants, but if a complaint is made against a non-judicial officer who's running, so a lawyer who's running for a judicial position, while the campaign's still happening, who takes jurisdiction then?
That's a great question, and that's not quite addressed by the rules. That's more a question of policy in a sense. Typically, if the Bar Association, if the Office of Disciplinary Counsel receives a grievance against a lawyer that is about campaign-related conduct, that's going to be deferred. Investigation of that's going to be deferred until the election is done. And there are a lot of policy reasons for that approach that I don't think I'll bore you with now. But as a practical matter, once the election was done, we'd know where that grievance would land.
And just so that I can follow up on that, there's another body here, which is not a disciplinary body, but they are an enforcement body, which is the Fair Campaign Practices Committee. So what Doug just said is true. I think what's going to happen both from the commission perspective and the Bar Association perspective is if there's some campaign violation alleged, they're going to wait to see who has jurisdiction after the election is over. Is this going to be an incumbent judge or is this going to be a lawyer? And that way they're going to divvy up who has jurisdiction. In the meantime, if you have a viable complaint, you can go to the Fair Campaign Practices Committee, or your committee can go there and file the complaint so they can expedite it and the public can look into it. Same with the PDC. So if there's a PDC violation, the Public Disclosure Commission can look at it, and then the Conduct Commission or the Bar Association can look at it after the election to determine who has the appropriate administrative jurisdiction. So, thank you.
Thank you. Yeah.
Okay. So I just want to echo my co-presenters' sentiments about all of you being here. And I know a number of you are incumbent judges and some of you would like to be judges, but I think all of you want to get it right. And that's by the fact that you are here on a day when my Audi registered at 71 degrees outside. So it's a pretty nice afternoon out there when you all came in here. I do note that Roger got 10 minutes, Doug got 10 minutes. I'm supposed to speak for 40, but it's only fair if I be much shorter. Let me synopsize. C1, C3, C4, F1, L1, treasurer, treasurer, treasurer. Are there any questions? All right. So, before I get into those acronyms, I'm going to talk about the financial aspects of running a campaign, and both the practical aspects of how much money do you need? How much money does your judicial campaign need? What are you going to use it on? And how are you going to raise it? So the numbers are real simple. There's a range, and it ranges from, for a Superior Court candidate, $1,666 will be the minimum expenditure in your campaign. From there, we go to $100,000 plus. For Supreme Court Justice campaign, we could be looking at several $100,000. And it really depends on what you want to do. So your campaign committee, the folks you rely on, and your finance committee, and you are going to decide on how much opposition you think you might get, how strong your candidacy is, and what you're going to have to do to run a successful and victorious campaign. And so I'm just going to throw out the whole ball of wax, and then you can choose from these as to what you think is going to work for you. Many campaigns, and I'm going back now to my personal campaign of 2000, and of course the campaigns of my colleagues who have consulted with me over the years. So, a campaign manager, a paid campaign manager, or campaign consultant. Very few judges or judicial candidates who I know have any type of permanent campaign, professional campaign manager. Almost all, or a vast majority of them, have some type of consultant. And you can budget that consultant for 5 hours a month or 10 hours a week, whatever you think you need. But that's one thing you want to look into, and this is a not inexpensive profession. You'll be charged quite a bit of money. Sometimes it's just a block of money, and sometimes it's by hour. It's whatever you work out with those professionals. But that's one professional source that you might have. And then you could have brochures, handouts, calendars. What's a calendar? A calendar is Husky football games, the calendar of all their games, or the Seahawks games. In the back it says vote for John Erlick for judge. And you hand those out at the stadium. You have Slim Jims that are basically the same thing, that instead of a calendar on the back they have all your endorsements or your bar ratings. You could have billboards. You can have bus ads. Bus ads are interesting. I think they're called, I don't remember anymore, but there's kings, there's queens, and there's something else. So there's different expenses, whether you want it on the back of the bus, the side of the bus that faces the sidewalk, or the side of the bus that faces the other side, the opposite sidewalk. But anyway, they all have different names, and they have charge different prices. Mailers. Mailers are very, very expensive, depending on what jurisdiction you're running. Obviously, if you're running for municipal court, you've got a lot fewer voters, and if you're running county-wide, certainly statewide, would be a very expensive. So you can make the decision. I'm just going to send this out to 4-4 voters, or 3-4 voters. Who are 3-4, 4-4 voters? Those are voters who are voted either in the last 4 out of 4 elections or 3 out of 4 elections. You want to get voters who are most likely to show up. This year's a presidential year, so you're going to get a lot more people who are turning out to vote for the up ballot, even though there will be significant drop-off to the down ballot. Ads, print ads in newspapers, TV ads. I rarely have seen a judicial TV ad, but I think last cycle there was 1 or 2 of TV ads. Social media is much cheaper than TV and can be just as pervasive and sometimes as persuasive. Now that we're talking about raising all this money for all of these things, let me tell you that money does not equate to victory. Money does not equate to victory. And we can certainly see that this year in presidential campaigns, where losing presidential candidates have raised tens, if not hundreds of millions of dollars and lost to the primaries. The same is true for judicial candidates. It sometimes can be reflective of the fact that you have a lot of support, but is your support deep? You've got some deep pocket friends, downtown lawyers, or is it wide, or is it personal? I'm just putting my own money into my campaign. In my particular year, there was a race between an incumbent commissioner and an assistant attorney general. The commissioner spent over $100,000. The assistant attorney general spent less than $5,000. The assistant AG won. So again, money does not necessarily translate into victory. What does? Well, my belief, and this is taken for what it's worth, I think that it often doesn't have to do with money. Newspaper endorsements, I think those are critical. They're not always dispositive. In 2000, when there was still a newspaper called the Seattle PI, With the endorsements, with the exception of the Times and the PI, which split on one race, the judges with the newspapers endorsed, the candidates with the judicial newspaper endorsements won. It was the rule that year. Since then, there have been more exceptions to that rule, but certainly that was extremely helpful in getting the newspaper editorial endorsements. Endorsements from community people. I think that they're important, but again, I don't think they're dispositive. If you're going to get those endorsements, get both sides endorsement. Get people who are associated with the R's and with the D's. Don't just get one side, and put it into the voters' pamphlet, because people know very little about judicial candidates. And lastly, I think the thing that is probably most important are your ratings. So if you rate well with the bar associations and the judicial evaluation committees, I think that, again, in my year, almost without exception, the candidates with the highest ratings won. And again, a lot of times those good ratings translate into the newspaper endorsements, and they also translated into general endorsements. So there's a synergistic effect between getting good ratings, getting community endorsements, and getting editorial endorsements from newspapers. Unfortunately, voters are very uninformed about judges and judicial candidates. In a presidential year, the drop-off is phenomenal. If 99% of the voters who show up vote for the president, it's a gubernatorial race, probably, I'm just making these numbers up, but something like 92% will vote for governor, and then it'll drop off from there to the Secretary of State, and then you get down to the judges. And by the time you're down to judges, you're down to sometimes 60 or 50 or less percent. Or sometimes, yeah, I remember that name, or I have a good feeling about that person. Well, they saw yard signs down the street. And that's another thing you can spend money on, is yard signs. By the way, nobody has ever done any studies or anything that I've been persuaded that shows yard signs have any effect at all, except on one person, the candidate. Makes them feel good. So it's really up to you as the candidate to inform the electorate, to inform the voters on who you are and what your qualifications are. And that's where the money really comes in, is how do you get that information out there? You're going to have the voters' pamphlet, and for most people, that may be the best source of information they have there. But if you can put in that voters' pamphlet that you got rated very well, or exceptionally well qualified by the King County Bar, and that you're endorsed by the Seattle Times, I think you're pretty well on your way. Okay, so let's go to the issue of who is going to raise that money. So the money, for the most part, is going to be raised by your finance committee. So you're going to put together a committee of people whose job it is to raise money for your campaign. They are going to have events which you will attend. They will not be holding any fundraisers that you will attend. You cannot attend a fundraiser. You will attend events. Now, it may be that they actually raise money at these events, but you have no idea whether that's happening or not. During this event, you may be asked to leave the room. And somebody might be doing something that you don't know about while you're out of the room. And you can select that person to ask to do this thing that you don't know about. And that can be your finance chair, or it could be your ask person. And that's permitted because you don't know if anybody actually gave money in that room. It's a fiction, folks. It's a fiction. But it's to protect the whole notion of impartiality and non-solicitation from judges, which was just upheld, as Roger mentioned, in the Yulee Williams case. So your finance chair is not going to be your treasurer. I'm going to talk about treasurer in just a moment. You cannot personally solicit money with the sole exception of family members, and family members are defined in the code as to who's a family member, how far out you go in per generation. Secondly, you can ask from finance committee members to contribute to your campaign. Now, here's another weird little thing you should know about, which is somebody can actually give you, you can't solicit it, but if somebody hands you an envelope and says, Judge, good luck in your campaign, or candidate, good luck in your campaign, you may accept the envelope. And then you turn it over immediately to your treasurer or to someone on your finance committee. So that's actually permitted, but you may not ask for the envelope. All right. So everyone knows the real estate adage, right? Location, location, location. In terms of raising finances, compliance with the PDC, treasurer, treasurer, treasurer. Aside from you as the candidate, the treasurer is the most important person on your campaign. This person can be a paid professional that you're actually paying to do this work, or it can be somebody who is a friend of yours who has done this before. Please don't ask your spouse or your domestic partner or whoever to do this for you, or your daughter, or your cousin. You will get into trouble. It has to be, absolutely has to be, someone who knows what they are doing. The PDC regulations are a minefield. That's all I can tell you. They are a minefield. You know, you can tell that they were put together by committee. They are not easy because there are a bunch of rules with a bunch of exceptions, with a bunch of exemptions to the exceptions to the rules. So you have to make certain that whoever you hire or appoint as your treasurer preferably has done this before and knows what they are doing. The last thing that you want is to be embarrassed by a front page headline of a judicial candidate not complying Public Disclosure Commission rules, because the public's going to look at that and say, this person can't follow the rules, how can he or she be a judge? So again, I think this is the most important person that you will choose. All right, let's talk about PDC. I would say, I think PDC probably puts on 8-hour seminars on this. I think they put in weekend seminars. I'm going to spend about 10 minutes on it. So please understand that I can only give you a very broad overview. A lot of this you don't necessarily have to specifically know about if you've got the right treasurer. But I want you to get this information, so you ask the questions about, did you get the C3 file? And they look at you like, C3? You might be looking for another treasurer. Okay, so first acronym is C1. C1 is basically registration with the PDC of your declaration of candidacy. That's what you are going to file within 2 weeks of becoming a candidate. How do we know that you are a candidate? You are a candidate when you do any of the following. You accept a campaign contribution. You spend money in support of your campaign. You reserve space, facilities, or broadcast time for your campaign. You authorize anybody else to do any of these things. You publicly announce your candidacy, or you file your declaration of candidacy. That's when you become a candidate. And once you do that, you have to file your C1s within 2 weeks with the Public Disclosure Commission. From then on, you have to file your financial information, including your F1s, and we'll get to F1s in a moment, your C3s and your C4s. Now there's something called mini reporting. Mini reporting means that you basically don't expect that you're going to be spending a lot of money on your campaign. And the limits are generally $5,000. $5,000 is the most you will expend on a campaign, and you will not accept more than $500 from an individual. And then you get to mini reporting. Otherwise, you are subject to C3, C4, and L1. So C3 is simply the information that the PDC gets, and I think it's monthly, and then it becomes weekly after a trigger period. I think it's after May. It's a weekly filing. And the C3 is for all donations, all cash receipts to the campaign. There's also a B, which is in-kind contributions to the campaign. A lot of people forget to file for or to submit that. So if someone's donating their space to you, that is an in-kind contribution. You need to know the actual value of that space, the fair market value of that rental space, and submit it as a campaign in-kind donation. Then the C4s are a full summary. The full summaries will have a list over, I believe it's the month, of all campaign donations and all expenditures. Then you have to list all loans. You may loan your contribution or your campaign up to $6,000 per election. So that's $6,000 for the primary and $6,000 for the general. It has to be documented, and that's the maximum amount that you can be repaid by the campaign. So you expect you're going to raise a lot of money, but you want to get your campaign kicked off. So you loan it $4,000. Then you get all this money in, you can pay yourself back, or your treasurer can pay you back those $4,000 so long as there is documentation of a note from the campaign to you. You can also expend unlimited, you, not your spouse. Your spouse is going to be subject to campaign contribution limits. But you may expend, and I never quite understood this given we're a community property state, but anyway. You can expend unlimited amounts of your own money with a limitation at 21 days before the general election, and then it's limited. You have to look up that amount. But up until 21 days before the general election, you can put in as much money as you want, but you can't get it back. You're capped at the $6,000 per election loan amount. So the most you can get back, if you give $50,000, and 12 of it is a loan, you can get the 12 back. You're out the other 38.
Okay.
Yeah.
So what if you don't have your own money? What if you have a joint bank account and it's all commingled?
I think that's your money.
Okay.
I mean,
Okay.
yeah, half, well, I guess half of it.
Sounds like the candidate has the right to check from that joint account.
Yeah, oh, yeah, unless he or she has a separate checking account. But you can write from that account, but I think if, you're, I don't know, I guess if your spouse is writing from that account, he or she would be limited to the $2,000 contribution. So you could write a $50,000 check. He or she could only write the $2,000 check. Or actually, 2,000 plus 2,000.
Okay.
Okay?
Yep, thank you.
Yeah. The loans must come, the loans from anyone else are subject to campaign contribution limits. So if somebody else wants to loan you money, or loan the campaign money, they can't loan more than 2 plus 2. You can get a commercial loan for up to $6,000 per election. So you can get up to a $12,000 commercial loan. All right. The C4, which is the summary, the monthly summary of incoming money and expenditures, must be verified and signed by the candidate. Now, this is an issue of some controversy. The code, if you want to look at the code, 4.2 on page 54 in your book, rule 4.2A2 says a judicial candidate in a nonpartisan public election shall comply with all election campaign, fundraising laws and regulations of this jurisdiction, which means the PDC. So the PDC trumps the Code of Judicial Conduct to the extent that you're knowing who's going to contribute to your campaign may create a potential basis for disqualification or recusal. Here's how judges and judicial candidates have done it. And it's pretty much all over the board. Some candidates look at it, they look at the names, and they sign it. Some judges, like the late Judge Hagan, wrote a letter to the PDC saying, I'm relying on my treasurer to make sure this is accurate, and I will verify that I've assigned that responsibility to my treasurer. And no one ever challenged Judge Hagan on that. The way I did it is I asked my treasurer to cover up the names. And then I looked at the money column, and I added up the money column. I said, yep, looks right to me. And then I signed off on it. And then I made a statement saying, I have verified the financial amounts. I have not reviewed the names for accuracy. Now, all of this, of course, the reason I don't want to know is because I don't want to know. I mean, sure, I know who showed up at my events, but I also know there are a lot of other attorneys that didn't show up at my events who may well have contributed. And I just don't want to know who they are. I think it puts judges in very uncomfortable and potentially compromising positions. Now, what do you do with that information, or what can happen with this information? If you would turn to page 31. Now, this is talking about disqualification of judges. So you're a candidate, you've now been elected. Congratulations. You get your big civil case on your docket, on your calendar, and the judge and the attorneys march in, and one of the attorneys works for Perkins Coie, and you know that that attorney and a whole bunch of members of her law firm donated to your campaign. So let's look at 2.1D. I'm sorry, 2.11, thank you, 2.11D. A judge may disqualify himself or herself if the judge learns by means of a timely motion by a party that an adverse party has provided financial support for any of the judge's judicial election campaigns in the last 6 years in an amount that causes the judge to conclude that his or her impartiality might reasonably be questioned. In making this determination, the judge should consider the total amount of financial support provided by the party relative to the total amount of the financial support for the judge's election, the timing between the financial support and the pendency of the matter, and any additional circumstances pertaining to disqualification. Now, if that wasn't drafted by a committee, I don't know what was. Justice Wiggins wanted a formula. And he wanted something that was going to be very clear that said, if you get this amount of money, that person should be appearing before you. And what about the Perkins Coie hypothetical I just threw out at you? What do you think? What if there's a motion?
The rule says adverse party.
Exactly. Thank you. Exactly. Everyone hear that? The rule says adverse party. Guess who contributes guess who 95% of contributors to judicial campaigns are? Lawyers. Unless you're at the Supreme Court justice level, and I don't even know how many corporations contribute to them. It's primarily lawyers. So the rule doesn't have really much of a bite at all. Now, that doesn't mean that a lawyer who contributed, that you shouldn't recuse if you knew a lawyer contributed to your campaign. But quite honestly, unless you just raised $10,000 and some lawyer gave you maxed out at $4,000, I mean, I just don't think that that's likely to be a basis for recusal or disqualification. But as Aaron pointed out, this rule is rarely going to be applicable for disqualifying. I mean, I don't really know who contributed to my campaign for the most part, but I would be shocked if there were any corporations or parties who ever appeared in my court. Okay, how are we doing here? Okay, I'm going to wrap up. All right. I think that's all I have. So I will, again, I grossly oversimplify this. It's quite a bit more complicated. Good news is there's software, and your treasurer can be trained on the software. It really is a question of just being organized and having somebody who keeps close track of that information. The only thing I want to add is under C3, if any contributor contributes $100 or more in the aggregate, your treasurer will have to get information regarding the contributor's employer and occupation. But there's all these little sub-rules like that. And as I said, we don't have time for that. The PDC has a booklet on judicial candidates that's about 70 pages long. So I've given you a synopsis of that, and I'll answer any questions that you might have after Judge Hogan has completed her presentation. Thank you.
I'm going to take the Doug Ende approach. My topic was putting the committee together and endorsements. And so Judge Erlick has talked to that, so I'm all done. But I do have the opportunity to scroll a little bit deeper now that he's laid the framework for that. So thanks, Judge Erlick, on that. I'm much more inquisitive, perhaps, than Judge Lee. I want to know who the judges are, sitting judges and justices in the court in this room now. Because there's some judges listed that I don't know. So who are our sitting judges now, other than the ones I know? All right, good enough. So a good number of you. Everything about our presentation needs to be sort of kept in mind as an overarching principle that those of you from the smaller counties have a very different goal and approach than those of us that come from a larger county, or certainly a statewide election, just as you might have, or from King County. So the practices of your individual county and the traditions that have followed before, you need to keep those in mind as you're marching through your decision making in seeking re-election or retention, or in seeking a position on any level of court. I have personal thoughts about the committee structure, and I'm going to talk about that from two perspectives. In the old days, we didn't have campaign consultants, and I'm talking about the 80s when I worked on so many judicial campaigns. We did it ourselves. We cut out the layout, and we put it down on paper, and we put together our committee, and we figured out what to report, and we didn't have professionals. This was not a cottage industry that it has become now. So when you put together a committee, hiring a consultant is one opportunity to make your work and your life so much easier. If you hire someone that you know can do the job, truth be known, I loved campaigning for a variety of reasons, and I'm convinced that my next job will be helping folks, incumbents, retain their positions, because I think it's such a wonderful opportunity to meet and greet the voters. A campaign consultant can help you be able to accomplish your goals in reaching the voters. They can make contacts for the Democratic and Republican endorsements. They can get you on a timeline of how you're going to put together your media, whatever you choose in the campaign that you put together. They can make your life so much more wonderful. The other thought about a committee is not to have a consultant, but you have a group of individuals, in my personal opinion, who are your best and dearest friends. Because, I'm sorry, lawyers don't elect judges, and they don't give you all the money you expect or need to run a $100,000 campaign. And you need to have people that will reach out into the communities where you live and are working, and that can reach out to those folks. So your campaign committee, setting aside the consultant aspect for a moment, are your nearest and dearest friends, and who will meet with you every week, who will analyze your strengths and weaknesses and help you put together a campaign that's representative of you. Your consultant can do all those things, but your friend of 40 years probably knows you better than a consultant that you've hired for this particular campaign. And so sitting down and having those frank discussions about analyzing your strengths and weaknesses and putting together a campaign that represents you can be accomplished with a steering committee of your nearest and dearest friends. And it's really from those folks that you figure out, do I need a professional finance fundraiser? Who's going to be the treasurer? Maybe we need a consultant to come in, who's going to keep my calendar, who's going to make all these other decisions. The third alternative is a combination of a consultant with a campaign steering committee. The problem arises if your consultant recommends, I think you should go down this path, and your campaign committee says, no, you might want to go down this path. And resolving those differences can be difficult. So, you know, in 2012, as Judge Lee suggested, make no bones about it, the women in Pierce County Superior Court bench were challenged. And getting 75% of the vote for three of us, you know, really sent a message. And having campaign consultants helped us reach out to the communities that we needed to overcome the challenges that we faced. So when you pick your consultant, and maybe you have a combination of a steering committee, my suggestion is that you pick those individuals who might be your named campaign chair, where your consultant is in the background, that reaches out and makes a statement about you and your community outreach. You know, you always say you want to have somebody at the head of your committee who's going to bring in the most votes. And that's not from the lawyers. Having a lawyer as a campaign co-chair is a great idea, but that lawyer may not necessarily bring in the votes from all the other organizations and affiliations in your community. So those are my thoughts on campaign committees. My thoughts on endorsements, which is my other topic, is getting endorsements from your friends is easy, and you should never be afraid to ask for the endorsements, or your campaign committee should not be afraid to ask your friends for endorsements. Having a list of endorsements is valuable because most of the time the voters come and say, well, you know, I don't even know what the difference is between a Superior Court judge and a Court of Appeals judge. So, you know, oh, but I see these 18 people who I know and respect in the community are endorsing a candidate. That might be reason enough for them to just go with the flow and recognize their respect for their colleagues or friends to endorse or to vote for you. So endorsements are invaluable, and you never know who a particular friend that you have might reach in the community. So it's always important to have a broad range of endorsements. The other endorsements that you need to seek besides your family and friends, your colleagues are always valuable endorsements to have, are those recognized organizations in the community. And I lump together the Ds and the Rs when you're in a campaign with a candidate with opponents. You can have partisan support. And you need partisan support. If they give you endorsements, they do a lot of work for you, and they can outreach into the political, partisan politics that we're not used to being in as judges. And it's a pretty scary thing to have to reach into that community when you've been basically prohibited under the canons from participating in partisan politics. The other endorsements that you want to reach out to are the endorsements of, well, sure, the newspapers are always valuable, and the ratings, which may or may not help you. Sometimes you have to be careful when you jump in. What will a negative rating do to you if your success in achieving that rating, or your lack of success in achieving that rating, becomes known in the community? Then you're going to be spending a lot of time defending that. So sometimes there's some very careful choices that you will make in not seeking an endorsement because you already know where the tide is flowing or which way the wind is bending on that. But you certainly want to be open to keeping it a broad-based series of endorsements that you go out and you seek. And from the consultant standpoint, you can certainly get a lot of help from your consultant. Those applications are tedious, they're time-consuming, and they're repetitive. Even though you think they're asking the same question, they ask it with a different twist. The other thought I had about endorsements is the most important thing in endorsements is to make sure that you have the endorsement before you publicize it. There's nothing more embarrassing than having someone contact you or your campaign and say, you know, when you asked me 3 months ago, or somebody asked me 3 months ago if I would consider endorsing you, I didn't realize you were running against John Erlick, and no, I can't endorse you, I'm endorsing him. I mean, and so you have to undo your publicity, you have to undo your endorsements, and it's just a series of back steps that you end up fighting over time. And it's better to make sure that your campaign, in following Canon for, is doing what they are supposed to be doing on your behalf, and that you really do have the endorsement. Because that is such an embarrassment for a candidate to find out that you didn't have the endorsement that was publicized that you thought was really special, but ended up not really being real helpful for you because you had to retract it. And making those public retractions are almost worse than, well, they're pretty awful. So, but in terms of campaign committees and endorsements, those are my general thoughts. And it's interesting because we put together the outline. We never sit down and go over what we're going to talk about. But I really had to notice that, and I think I mentioned this a couple of times before, it's really different how we are in Pierce County, how we are in King County, and for some of you from the smaller counties, how very different our campaigns can look. A successful campaign in Kitsap County, I don't know what they spent last in 2012, but it felt like it was about as expensive as it was in Pierce County, which is not nearly the money they spend in King. So those are my thoughts on endorsements and committees. If you have any questions on those two topics, otherwise I'll switch over and talk about some of Judge Erlick's topics, financial aspects of running a campaign. All right, Judge Lee, then I think we've come to the end of our presentation.
Thank you, everyone. Are there any questions for any of our panel members that may have cropped up while they were speaking? I know you folks asked some good questions, just as you.
Yeah, Judge Erlick, I was just wondering if you might say something about campaign debt, and you know, it's sort of after the fact in terms of either time limitations,
Right.
When you might have events to pay that debt.
You know, the PDC does allow, and I believe it's 60 days, but I'm not positive, after the general election is over to retire campaign debt. I would need to confirm that time period. And it's going to be subject, of course, to the campaign contribution limits. So you want people to show up who haven't contributed the maximum amount for the judicial campaigns. Because that's going to be a problem for some campaigns. But I believe it's 60 days after the general election, you can hold an event and retire for purpose of retiring debt.
It sort of as a follow-up,
Yeah.
let's just make the assumption
Right.
that there's a debt, there isn't really a campaign, for example, let's just say that I don't have somebody filed, so after the primary, there still may be a debt incurred up until that point, so that probably
Right.
would move up, I would guess, until after a primary if you don't go to the
Okay,
general.
so the question then is, don't you go to the general though? Even if you don't, even if you
You're on the
don't get
ballot,
an
which is
opponent,
different than, right. So
you
let's just
still-
assume non-contested election, that's right, I'm still on the ballot.
right? So the question then, you're asking, so I still think the 60 days apply. So even if you don't have an opponent and you have campaign debt, I believe that the 60 days would apply, regardless of having an opponent.
The real question becomes is if you have a campaign surplus and no opponent after.
That's different.
After the,
Yes.
Right.
yeah.
And the rules are pretty clear, I think, on the
Yeah.
surplus.
Right, the
Yeah.
rules are clear on the surplus, but I think given that you go to the general regardless. I mean, in theory, I don't know if there could be a write-in or not, but you're going to be on the ballot. Judge Nelson.
Judge Erlick, I wonder, my understanding that not that I had any surplus or that I needed to worry about, but I understand that there's a particular rule for King County judges about carrying over surplus, and I wonder if you might speak to that.
A King County rule?
I thought that
That's
there was.
not PDC and not CJC?
Look at the city ordinance.
I'm not aware of anything. I don't know where.
Okay, you don't,
No.
all right,
Are you talking about surplus funds?
yes.
No, not to my knowledge. And Judge Rosen is shaking his head that he's not
Okay.
aware of anything.
All right, I heard an urban myth, thank you.
Yeah, I'm not aware of it.
RCW 42-17A43.
Yeah. Yeah, the statutory. And it lists exactly where the funds have to go, or can go.
I have a question.
So,
On that subject. I've always been curious. There's a whacker, and I don't know off the top of my head. I know it wasn't passed by any of you. But I thought maybe some of you have talked to somebody in the PDC about it that indicates, and I believe only for Superior Court candidates, if there is a surplus, it must be returned at a first in, first out basis within, I think, 14 days of the end of the election. I've never understood why that is, why it only applies to Superior Court, or most importantly, why it's first in, first out. Because it discourages people from donating at all, because, let's say you wanted to get a big donor to kick off your campaign with the $4,000, they're much better off waiting till the end, till there's other campaigns. Does anyone know why that is?
I have no idea behind it.
But the logic behind it was for a priority, because you look at the money that you've received and you don't have an opponent, but you have all this money. You go, now I'm looking at my C3s to see who gave me money. Oh yeah, I want to give money back to, this attorney. Oh, I really like this attorney. There has to be some, fair way to return the money that makes sense.
I always just assumed that fair way would be proportional, but,
Right.
and it only applies to Superior Court, so I didn't know if there was something at play I wasn't understanding.
Yeah, I don't know very many Superior Court races in 30 years of working on campaigns that have surplus funds at the end. You might have enough when now there's a very low limit on repaying your loan. It used to be a little bit higher. But surplus funds repay the candidate for the, gosh, if you could run it for $12,000, wouldn't that be nice? Well, should we give our 5 top suggestions, Judge Lee? We talked about that.
Are there any other questions?
If we need to burn time, I have another question.
We're here to answer your questions, please.
This may seem overly sensitive and a little crazy, but my kickoff, I've got a campaign sign. My wife is a photographer. She took pictures of my kids around the campaign sign, and it's really cute. She gave me this as a present, said you can hang it in your office. And I said, I'm sorry, I don't feel comfortable hanging it in my office because it has, it's an 8x10, it's got a little section on my campaign sign. And so I haven't hung it in my office. They're disappointed. I'm here with the ethics gurus. Does that change at all if I win or lose the election, if I stay in municipal court or if I go to Superior Court after the election? Do you put anything of your paraphernalia at all in your office?
Well, keep in mind that we run on the scale here from, as I always tell new judges, the most conservative courtroom to the most liberal. I don't care about what the Code of Judicial Conduct says.
I'll go with conservative.
Okay, no. First of all, you have a county rule in Pierce County, no campaign literature in that building. So I'm way down here, the moral compass of the court. No, take it out of your office. Why would you want it in there, first of all, in a county facility, campaign material? I mean, we don't make phone calls and talk about campaigns on the county phone. We don't use our emails. We all have our iPads and our texting on our personal phones on personal time, and no.
So this is a picture of one of your kids holding all 4 of your kids, each holding a campaign.
No, they're just a round sign. A standard yard sign. It's not in my office, so that's clear. I didn't bring it in because I was thinking maybe I don't think I should bring this in. But I thought maybe after the election, if I asked you and you guys said yeah, then I could tell them. You said no, then I could tell them that too.
Tell them we said no.
It says elect Steve. It says elect.
Something like that.
Yeah. Steve Rosen for Superior Court judge. And if you become a judge, you're not going to be elected. You're going to be re-elected. So I don't know. I think we have to draw the line somewhere here. I wouldn't be offended if I saw it in your chambers. I wouldn't put it in the courtroom. But if it's in the chambers, I don't think it's campaigning. I think it's a picture of your kids. And if you have to, you disagree.
Well,
There's no
I know
campaign.
the Pierce County ethics rules are modeled on the federal rules, Judge, and so as a former legal advisor to general officers, my first advice would be absolutely not, period. And why run the risk that a disgruntled employee is going to make an ethics violation complaint or whatever, just for the efficacy of having your kids in a photograph with your campaign sign?
But my feeling is the campaign's over. There is no campaign. It's over. It's not campaigning. And I'm usually the conservative on that.
Still campaign literature, but like I said, you have a spectrum.
I'm
with you.
But
Just don't bring it in.
just put the picture up there, and just put a little duct tape.
Have a digital print.
Yeah, Photoshop it.
Photoshop it.
Put it on your
Select
phone.
card.
Yeah.
Post-it note with the sign.
Any other questions?
What else do we have? Do we have a written one back there?
I just wondered if you wanted to pick up if anybody.
Yeah, does anyone have a
I'll walk
3x5
around, you
card
just
that they
pass
might
them
have
so you
written
can
on?
have it.
Does anyone have a submission they want to do
I don't feel like we have a
anonymously?
shy group here.
Yeah.
Well, if not, we were prepared for this situation, and what we've done is we've asked those who have run a campaign to come up with 5 words of advice for the group for your campaign. So I'll start with Judge Hogan.
Well, the one thing I've always told attorneys who have come in over the years and asked me is, decide why it is you want to become a judge. There's lots of reasons, they're all valid. But by gosh, you have to want it from the top of your head to the bottom of your feet, because when you're on the campaign trail and the public doesn't feel that from you, then you're going to have a hard time winning an election. Judge Erlick's right, it isn't the amount of money, it's the connections you make in the community outside of the lawyers. And citizens, regular folks, know when you really want this and when you don't. And I don't mean that you're effervescent over the top, They just know they can feel the sincerity and the honesty, and that you really want this, and this is pretty much about as important as hanging that picture in your chambers if you win the election to Superior Court. The second suggestion I would have is that you're going to have a timeline, whether it's with your consultant, your steering committee, whatever it is. Stick to it. Do not deviate from your timeline. And everyone will have suggestions for you. Oh, you need to be putting up your yard signs. Oh my gosh, you need to have your newspaper endorsements in the paper now. You're never going to be on their timeline. You need to stay on your own timeline. Make sure you know what it is, and thank everyone for their wonderful suggestions, but don't second guess what you and your consultant or you and your steering committee have decided. Okay, so in '92, I had a timeline, and my opponent did not, and he tracked behind me 30 to 60 days. He didn't know what to do. He didn't do his timeline. He tracked mine. And 60 days after the election was over, he finally realized he didn't win. You need to stay to your timeline. And the suggestions that people may have may be well-intentioned. Oh my gosh, you need buttons, you need t-shirts, you need those yard signs. If you don't have the money for it and it's not in your plan, then don't go there. Just say, what a great idea, thank you very much. I'll talk to my committee about it. Don't blow them off. That may be a great idea. You may revise your timeline, but don't necessarily think that you're behind the game because other people have other ideas that you haven't adopted. I already talked about my third suggestion is have that frank discussion with your committee. Whoever it's composed of, your consultant or your friends, know what your strengths and weaknesses are. Are you too old? Are you too young? Are you too whatever? But be sure that you know what your strengths are and what your weaknesses are, and then address them as you need to. I personally think a good suggestion for your campaign is to run your campaign on your strengths. And don't spend your time attacking the other person. It doesn't bode well. I think we've seen that in presidential campaign right now. Just run your campaign and run with your strengths and why you want to be a judge at whatever level of court it is. Like I said, and you really, really, really have to want it. Because I asked somebody the other day, well, why do you want to run for judge? And they gave me this very nice statement. It sounded swell. And I said to them, so the Pierce County people will understand this, I said, that's not going to sound or play well on the east side. When you know your districts in your county, what you may say to the downtown civic organization isn't going to help in the hilltop or where the shootings are or where the crime is. You know, you need to be broad-based in this. It needs to be above the theoretical. Serve society and give back to the community. I mean, that just isn't enough to run a strong campaign. But those are my suggestions.
I don't have a lot to add. I would just say that when you think, and I'm really addressing this to the non-judges, the judges know what it's like to be a judge, and they know what the job's all about and why we want to keep it. It's a great job. It really is. It's a privilege to serve as a judge. But as you're putting your name in there, I think it's so important that we be circumspect. It's really a dramatic change of career and how it affects your life. And I put together what I called my tough love group. It was my steering committee, but they were my tough love group. And sat them down and I said, I'm thinking I want to become a judge. What do you think? And they were very supportive, which was good. Because I've been before this group, same group before, and I talked about other political positions, and they turned me down and said it was a horrible fit. They said this is a good fit. You know, ratings are controversial. Endorsements from the bar, or not endorsements, but the judicial ratings are somewhat controversial for a number of reasons. But I think it's important that candidates go through it. And the reason is, sometimes we think we know ourselves, but we don't know how other people see us. And the ratings are an opportunity to get that type of as objective reflection as we can get. Some people think it's maybe not fair, but I think it's some of the little feedback we get. So when you go there and they say, you're just qualified or you're not qualified, you need to say, well, what did they see in me that I don't see in myself? That why I wouldn't be qualified to be a judge. Because I think I'm qualified to be a judge. So I think in that respect, we need to sort of step back and not only look at ourselves, but have others look at us and give us that input and be prepared for candidness in your life. My philosophy of life is that there are no good experiences or bad experiences. There are just experiences. Because so long as you come out alive, it's just another experience. And believe me, I have traveled around the world in places where I question that sometimes. But I'm here. And the same thing can be said for a campaign. You know, for me personally, I'm really glad I did it. And I would prefer if I never have to do it again. And, you know, try to have fun. It really is a remarkable, once-in-a-lifetime, eye-opening experience. You know, we're going through the presidential campaigns right now, and we're going through a whole bunch of campaigns, but this is the one we see on TV every night. And we see these people out there, and we watch them and say, who are these people? And when you go out to the bus stops at Northgate, or the legislative district meetings, or the Husky football stadium, you engage in, these are the people. You're going to hear from people in a context that you may never hear from again. Because in your courtroom, they have a lawyer next to them, typically. So they're not going to tell you what they're really thinking. Outside Husky Stadium, they will. And they'll tell you what they think about judges, and they'll tell you what they think of our criminal justice system. And it's your job to explain to them why you can't commit on this issue, why you're not, quote unquote, voting this way, because judges don't vote. Judges aren't other elected officials. I have to say I was a little shocked when Chief Justice Roberts came out with a statement and said, judges are not politicians, because it really was as much as a reversal as there could be of the Republican Party versus White decision. Because in that decision, they basically said that judges are just like all other politicians, and if you don't like electing them, then don't elect them. That was basically what Justice O'Connor said in the opinion. Since then, she said that she thinks it's one of the biggest mistakes she ever made, being in the majority in that case. Anyway, bottom line is, it's an amazing experience, and have fun, and I wish you all well.
Mr. Ende, you've participated as a panel member in many of these, so if you could give this group your impressions and advice that you've gained throughout the years.
Oh, that's an interesting question for me. My knowledge of the regulation of lawyer conduct in judicial campaigns is largely theoretical, as perhaps you could tell from the content of my presentation. And that's because in my almost 20 years doing lawyer discipline in Washington, there have been very, very few grievances against lawyers relating to purely campaign conduct. Now, very few does not mean none. There have been some, but there is not a depth of precedent around lawyer conduct in judicial campaigns. There probably isn't even a depth of precedent around judicial conduct in judicial campaigns. So that said, I would like to leave you with a hopeful note. unfortunately I don't have one because I hadn't really thought through what my practical advice might be. Would you take 2 discouraging notes? It's possible that a grievance might be filed against you, and it's possible you might be moved to want to file a grievance during the course of a judicial campaign. Again, in my experience doing professional discipline, making that decision in the heat of the moment is not always the best time. It may happen that something will occur during a judicial campaign, an opponent will say something that makes you very, very angry, passionately angry, determined to do something. And that state of mind is not a good state of mind in making the decision about what to do in that situation. As a practical matter, and we've talked about this already, what will likely happen if a grievance is filed during the course of the campaign is that grievance will be deferred, which means nothing will happen. It will be put aside pending the outcome of the election, at which point a decision will be made about whether it ought to be looked into. In my experience, post-deferral, the individual who filed that grievance tends to lose interest in the outcome of that investigation. Everything is now said and done. The election is over. Someone has prevailed, someone has not, and people want to move on with their lives at that point. So I guess if I'm going to leave you with a thought, when you feel that intense and passionate anger and you think the answer may be to file a grievance, I would suggest pausing. It doesn't mean you will never file that grievance. I would suggest using that energy to compile the information that you think establishes perhaps a violation of the Code of Judicial Conduct. Gather it up or delegate it to someone who can do that for you. Put it in a file, a paper or an electronic file, set it aside, and go back to it when the election is done. And if you still feel that righteous sense of anger and you think the grievance is the best way to ensure the health of the profession of law, file it then. It will be better for the system, it will be better for you, it will be better for your opponent, for the objective evaluation to be done at that point.
And thank you for that. And just as a follow-up, if you really can't put it into a folder and you really need to do something, I refer you to Code of Judicial Conduct 4.1, comments 8 and 9, which gives you some ways you could try to counter whatever it is that has offended you. So take a look at the comments 8 and 9 under Rule 4.1 in the CJC. It's my turn, isn't it? And we had talked about having 5 words that would be good advice for everyone in the audience. I have 4, because I don't like to talk more than I need to, and my 4 spells the word ripe. So if you remember nothing else with this, remember ripe. R, be respectful. Be respectful of your opponent and respectful of the election process. And I will confess that our national election for presidency has been coloring my thoughts lately. I maintain your integrity throughout that process of election. You'll be challenged. You'll be challenged sometimes to the point where you really want to stoop lower than you would normally. Don't. Maintain your integrity, because that's all you'll have at the end of the process. P, professionalism. I'd add into that civility. How you choose to run your campaign and how you carry yourself throughout the campaign. Do it in a professional manner. And E, be ethical, which all of you are evidencing that by being here today, you're learning about the code, you're aware of it at least. That's good, because some candidates are not even aware of the code. So I leave you with right. And I want to thank you for being here this evening. I hope you've learned something that might help you along the way. If nothing else, at least you have the materials that something will trigger and you have somewhere to go. This committee, the committee, just for some of you who may not be aware, we are the State Ethics Advisory Committee, which is a committee that judges around the state go to get advice to try to stay out of trouble. So we're the front end. I consider us the front end committee. There's also the Commission on Judicial Conduct, which is more like the prosecutor, the back end, where someone files a complaint, that's who they file it with. And they do the investigation and mete out punishment if they find it is founded. So the Ethics Advisory Committee is the front end. We're your friends. We try to keep you out of trouble. And Shannon Hinchcliffe, again, is our AOC staff member that helps this committee, and she is always available. I'm always available to answer any questions that you may have. So if through the course of this election you find you have a question, think Shannon, think myself, think committee members, we're here to help you. All right. With that, thank you very much. Have a good evening. Drive safe.